For the last few months, I have been the Chief Information Commissioner. Therefore, I thought, let me not talk on criminal law, let me talk on the subject which I am currently doing. And the subject is the Right to Information Act 2005. Now, why do I talk about it? It's a very, very enabling act. And what is an enabling act? An enabling act is an act which empowers a common man, a citizen of India. Now, under RTI Act, you see what we are trying to do is that any citizen of India, even if you are an NRI, you have not renounced the citizenship of India, or even if you are a government servant, primarily you are a citizen of India. Therefore, any citizen of India has a right to ask a question, has a right to seek details, and has a right to seek information from any public authority. Now please mark the word public authority when we say it implies that anything that is based on a government. Now the question that arises is, what is a public authority? Now you may be in a various institution. To give you a simple example, supposing you are studying here in CMR, does RTI apply to CMR? This is a simple question which I am asking you. And when they come in appeal to the commission, which is called Karnataka Information Commission, what do we adjudicate? We adjudicate whether you come under the definition of a public authority or not. And if you do come under the definition of a public authority, I have a right to seek information. This is the underlying subject of RTI. Now, if you say that I am not a public authority, then you have to substantiate that how you are not a public authority. Now, let me give you a very classic example. Those who are in Bangalore, you must have heard of Bangalore Golf Course, of BGC. It's a very old club. 1856, British period. Whenever you go, you see it on the other side of the main road. Now the question was asked whether BGC should give information or not about the club. And the matter came to the Karnataka Information Commission. And then the question asked was, they denied, they said, we do not come under any definition of a public authority. Then the matter went to the High Court. And what did the High Court say? High Court said that if in any format you have taken assistance of the government, then you qualify to become under the public authority. And therefore BGC was asked. Now what was the reason given for the BGC? They have got government land on a very long-term lease on a very punitive rent of 1,000 rupees per annum. Now this was the reason given. And once you are availing of any facility from the government, whether it is be in a land or a financial grant, you come under the definition of a public authority. And that is where the BGC was asked to give all kinds of information which a common citizen would like to obtain. So why I am giving you this example is, any kind of assistance, if you are seeking from the government, you are liable to be accountable. And always remember, RTI is for transparency, RTI is for accountability, and RTI is for making your functioning as open as possible. So with these opening words, I start my few slides which I just wanted to share with you. RTI is not in the curriculum of LLB, if I am right, because RTI has still not been included. But it is a certification course, and it is a very, very effective course, because for a country like India, we have implemented it, and I will give you certain details through which you can make out how popular RTI is in India. So let me start with few of the slides here. Now this is the preamble of the RTI, and what does it require? It says that democracy requires informed citizenry, transparency of information. And why do you need that? To contain corruption, hold government and instrumentalities accountable to the governed. This is what is the preamble. And the reason is that we have to ensure that people do not make money out of the taxpayers' money. And that is why one of the important objective is corruption has to be curtailed. Transparency, the more the transparency, the less the corruption. The more you hide, the more shall be the corruption. And this is what is the broad objective of the RTI. Now if you see the first line, tilted balance of power from those who govern to those who are governed in a democratic framework. What does it imply? As I told you right in the beginning, a citizen can ask any question. If I hold a high office, I am accountable to the citizen. He can seek information. And that is why the balance of power was shifted from those who govern to those who are being governed. And that is the famous thing, the objective of the RTI Act. Now, I have given you CIC and SIC. CIC is Central Information Commission. SIC is State Information Commission. Now, all these are statutory bodies. What do you imply by a statutory body? The RTI is an act passed by the Parliament. Therefore, it is a statutory body. It is not a constitutional body. The difference is, if permitted by the Constitution, it becomes a constitutional authority. This is only a statute, and that is why it's a Parliament statute. Therefore, all the State Information Commission are bound by the Central Act. No amendment can be brought by the state legislature. Whatever is the Parliament enacting, it has to be scrupulously followed by each of the commission. And that is where it requires public authorities to provide access to information. Appoint PIO. What is PIO? Public Information Officer. PIO. So every department, every ministry, every government organization and every public authority will have a PIO by designation. And that is what is the first applicant goes to the PIO. They don't come to the commission. And the PIO, as per the Act, must provide information within 30 days. There is a time schedule for that, 30 days. Publish certain categories of information, power to hold inquiry, powers of a civil court. So all the State Information Commission is equivalent to a civil court. And what are the characteristics of a civil court? I have listed out. You can enforce attendance of persons. You can ask for discovery of documents. You can receive evidence on affidavit. And you can issue summons for examination of witness and document. Now this is what a civil court performs. This is what I do in my Karnataka Information Commission. If the people deny information, what do? I give a hearing date. I make the applicant appear before me. The applicant can either appear in person or through his legal counsel. And he will argue that I need this information. Now I'll give you several instances once I have given you the brief on the SIC and CIC. Now the difference between CIC and SIC is central information for all the central government, state information for all the authorities coming under the state government. Now the Honorable Supreme Court in 2019, information commissions are vital for smooth working of the transparency law. This was a very important because what we found over the last decade, the number of information commissions in various states became defunct. Now what is defunct? The state government did not appoint a single information commissioner. With the result, no hearing, no appeal was entertained. And the result was the whole RTI Act started becoming non-existent. And thereby, again into 2023, Supreme Court set a deadline to all the state governments. You must comply with the appointment of information commissioners within 6 weeks. And thereby, now we see today, most of the state information commissions have once again been activated. So always we find the court intervention has allowed this commission or this act to be lively, to be more versatile. Otherwise, you would have realized in your LLB program, number of social legislations are passed, but they are never implemented. And this is one of the acts which always faces the danger of getting eliminated by virtue of negligence. And that is why we keep having Supreme Court interfering and making this act very vital. Now, RTI of 2005 provided for protection of privacy of individuals under Section 8. Now, I am not running through all the section, I am just giving you a brief overview. What is Section 8? Where can you deny information? Please remember. And you have a right to deny information. A PIO, what we call Public Information Officer, can deny information on these grounds. Number one, no relation to any public activity, no relation to any public interest, unwarranted invasion of privacy. Now these are three important grounds where if you come to me seeking information, I can deny. Now we get a lot of applications. You see personal details, asking for where is your child working, where is your child studying. Now we do not provide such information. Or where are the family members? Because it is a right of privacy and no person is authorized to seek such information. And it should not be put on a public domain. Why? Because it can create the issue of personal security. Now those who are reading social media, those who are reading newspapers, you will find the Indian Foreign Secretary was briefing the media on the build-up to the war with Pakistan. Suddenly when he declared ceasefire a day before, he has been trolled on the social media. Why has he been trolled? A lot of people started mentioning that this was what was expected out of you, and then made some uncharitable remarks on his daughter, who is also pursuing a law program in Oxford in London. Now all these are personal matters. No person is allowed under any act to get into the privacy of any individual, whether he is a government servant or he is a private individual. And that is where you will find now several acts have come. RTI was for transparency, but you cannot invade the privacy of any person. And now we are going to have another act very soon, Data Protection Act, which totally bans any personal private information in any domain. Now in RTI, the one fundamental issue was any information which you can share with Parliament or state legislature must be shared under RTI. Now that itself will get circumscribed once the Data Protection Act comes. Now you are already aware, IT Act, anything which you make defamatory, derogatory on anybody in your social media comments, you can be prosecuted under the IT Act. And that is how there is always a debate whether expression of freedom and the right to have your privacy both can come together or not. And the Supreme Court repeatedly has emphasized that freedom of speech and expression should not intrude into the right of privacy of any person. And that is why in RTI Act, we do not provide information bordering personal information. Please remember, the underlying factor is public interest. Now this is what is the act I was telling you, Digital Personal Data Protection Act. It will amend section 8 and all personal information will be taken away from the ambit of RTI Act. So anything vaguely connected to your personal thing will also disappear. Please remember. Now there is a lot of criticism because RTI faces the danger of getting redundant. But if you ask me, the right of privacy is a fundamental right and you cannot abrogate it under any circumstances. Section 81J, information which cannot be denied, which I have already mentioned, Parliament or state legislature can be provided under the RTI. Now let me talk about the All India scenario, how much application we receive. We get about 40 to 60 lakh applications filed. In Karnataka, we are getting about more than 5 lakh petitions filed every year. Now what does it imply? It implies that RTI is quite vibrant. Now if you compare it with the total population, this figure may appear very small. But even 60 lakh, which has now further gone up, is a very significant number. And that is where I feel that if you become a conscious citizen, you will find this number will keep increasing. And it also pinpoints to the fact that the legal knowledge of our community has improved, literacy has improved, awareness has improved. We do not have to conduct mass awareness on RTI Act. People are aware, therefore they file application. Otherwise, one of the job of Information Commission is to make people sensitize on the RTI Act so that they can exercise the right to seek information. Now, 5% appeals complaints filed with ICs. What does it imply? You see, most of the application under RTI must be disposed at the level of PIOs. What is PIO? Public Information Officer, which each department has been designated. The KIC, the Karnataka Information Commission, only takes those applications which come as an appeal. And they come as an appeal on the second appeal. We call it second appellate. Beyond us, there is no appeal. Then if you are aggrieved by the order of the commission, what is the outlet you have? The only outlet is that you file a writ petition in the High Court and seek justice on the pronouncement made by the commission. This is only, but because the second appeal ends with the commission. The next one is 45% RTI applications successful in obtaining information. Now if you see, out of the 60 lakh application, only 45% are getting information. What is happening to 55%? The remaining 55, they are denied information or they lose interest and they do not get information. Now quite a few will come under the category of personal information, so they get rejected. The second category would be, lot of institutions may say that we do not come under public authority, therefore they do not get information. So our satisfaction level is about 45%. And if you ask me, I would like to increase this 45 to at least, not if not double, in the range of 70 to 80%. Then only I would be able to claim that RTI is a vibrant act. It serves the requirement of a common citizen. The remaining 55 all end up somewhere or the other. Now we come to, this is your basic information which I thought I'll share with you. RTI prescribes statutory timeline for disposing information requests. Now you see, you have done criminal laws. Nowhere you will find that there is a timeline prescribed until, let me add to this, until we had new criminal laws coming up last year. And in the new CRPC, if you read, what is the basic difference between the old CRPC and the BNSS? You will find after end of every section of law, there is a time limit prescribed. And what is the time limit prescribed in CRPC, new CRPC? Every investigation must be completed in 90 days or 60 days. There is a time limit for the court to take cognizance of the charge sheet. There is a time limit for closing the trial. So all these are time limit now prescribed in the criminal law. In RTI, there is a time limit. And what happens if you do not give information within the time limit? We will come to that. 30 days from the date of application. Second appeal, no time frame. First appeal, 45 days. So if the PIO does not give you information, you can go for first appeal and then you can go for second appeal in the commission. And the Supreme Court for second appeal, since there is no time limit, has said that maximum within few months you should dispose. Now the problem here comes is that most of the Information Commission do not have regular commissioners appointed for years together. And that is why the pendency or the time schedule is not maintained. And you visit any Information Commission, you will find huge pendency, more than 3-5 years pendency. And the reason is not with the commission, the reason is non-appointment of the Information Commissioner. In Karnataka, we have 50,000 appeals pending, which is a huge number. And the main reason was that our commission was having lot of vacancies, therefore we could not dispose as many petitions as what we would have liked to do. 70% of RTI applications should have been proactively made public without citizen filing RTI application. Now what does it mean? There is a section 4 in the RTI. It is mandatory for every department to upload all the information concerning the department without being asked for. So if you want to access any information on anything, for example, you want to go abroad, you want to know where to file your passport application, where to file your visa application, where to get your police clearance certificate. Now all these must be automatically loaded on the website of the department, so that you don't have to run with an application seeking such general information. All rules, all circular must be on a natural mode or an auto mode uploaded. Therefore, the number of application in the RTI will automatically reduce. We come to the last one, Section 20 RTI Act. Information commissioners can impose penalties up to 25,000 rupees on the PIOs for violation of RTI Act. Now this is the maximum punishment we can give, fine. And the fine has to be paid out of his salary, not the government. And if he has mischievously, repeatedly not provided information, he can be liable for fine. He can be liable for disciplinary action, which includes suspension, which includes holding of his increments in salary. All these have been provided in the RTI Act. So a government servant must be proactive in disposing an RTI application. Section 19(8) empowers Commission to award compensation to information seekers for any loss or detriment suffered. So even I can compensate. For example, we get a lot of cases where illegal detention of a person has taken place in a police station. And thereby, Section 7 of RTI says within 48 hours, you must provide the information. Now, if the PIO does not provide information, we can fine him under Section 19(8) because damage is caused, he was kept under illegal custody, and therefore he needs to be compensated. He is a victim of arbitrary functioning of the police officers. Now in Karnataka, let us talk about Karnataka just to give you a more relevance to what we are talking today. Composition of KIC. We have about 10+1 commissioners in our commission in Karnataka. That is the maximum permitted by the Act. Out of these 11, this has been the composition. Retired government servant about 59%. Lawyers or retired judges 19%. People who are doing social work 11%. People engaged in business can be appointed as an information commissioner, very few, but 4%. Journalist, 4%. Currently, we have about 4 journalists working as an information commissioner in the Karnataka Information Commission. Academic, any professor, any doctor, any teacher can also become an information commissioner. Why? Because the Act says people of eminence can be appointed. That is why the range for people to get appointed as information commissioner has become very wide. Anyone less than 65 years can aspire to become an information commissioner. Now we come to appeals for 23-24. Registered 24,000, disposed 28. Some backlogs are there, that is why that figure becomes 28. Current year, we get 24,000 application in the received in various departments, that is by the PIOs. Pending 50,000 at the commission level. Estimated disposal time 1 year and 9 months. You see the estimated disposal as per RTI Act should be 30 days. So we are far exceeding the disposal. Penalties imposed 93 lakhs, and in which penalty very small percentage penalty was imposed. This is the only punitive section provided in the RTI. Transparency. Latest, we have not published the annual report. We are soon going to publish the annual report. IC orders on website, yes. Success rate of RTI application 92%. Hearings open, anyone can attend the hearing and sit in the court hearing and listen to the procedure followed in seeking information. Hearings live streamed? No, so far not done. So this is what is a brief presentation on the KIC. Now let me give you some illustrative cases. I don't want to make it too academic for you because you can read the RTI on your own. It is just an introductory lecture on RTI. Now my question is, what kind of application we get? Now if supposing a third person asks for your mark sheet, on what basis you have been admitted in a particular institution, can he be provided or not? And if he is not, if I deny, then what is the ground under which I can deny? Now please remember, a mark sheet is a personal thing. Please remember, even if you have submitted your mark sheet in the college, and if a third person asks for your mark sheet, the college can deny. Why? Because it's a personal thing. No third party can access your personal information. Please remember. Similarly, for a person who is employed in the college, if I want to know his salary details, can I get it? Again, there have been several instances where payslip is a personal payslip. We cannot disclose the payslip to a person. Now let me come to the criminal law. We get a lot of application on CCTVs of footages of a police station. Now what is the CCTV footages as per the mandate of Supreme Court? Every police station must have a 24-hour CCTV. Why is it required? Because nothing illegal should happen in a police station. So if you visit a police station today, you have a right to ask for a CCTV footage. Now what is the problem when it comes to us in an appeal? Because most of the police officers deny the CCTV footage. And the reason given is that when you seek the CCTV footage of about 2 hours between 8 a.m. to 10 a.m., the regular reply received from a police station is, sir, there were a number of people who visited police station at that particular time. Some were victims of POXO Act, some were victims of Domestic Violence Act. So the CCTV footages contain lot of other information than what he is seeking for. Now it becomes very difficult for us how to go about in such matters. Because you cannot, you see, a POXO victim or a domestic violence victim cannot be disclosed to a third person. And that is why the CCTV footages you will find in 90% of the cases gets denied. Now one way out is you can ask the police station to use cyber, delete all the irrelevant, not needed portion and provide only details which the applicant is seeking for. But again we hit the wall by saying that sir, technology is difficult to remove, delete, and in the process of deletion the vital portion what he seeks will also get deleted. So these are the hard realities when you preside over in a court of KIC. You have to take a balancing call, because tomorrow if I intrude on the privacy of a third person, I may also be liable for prosecution because I am disclosing details which are not pertinent to the matter. Second problem that we face in a criminal law, station house diary. Have you heard of a station house diary? Station house diary is a 24-hour document written on an hourly basis of all the activities taking place in a police station. SHD is maintained in real time. Now, a lot of people seek copy of the SHD. Is it possible to give? Again, difficult to give because SHD contains much more detail than what can be allowed to an applicant. The third question came to me very recently since I have a police background. Case diary. Now you know what is a case diary. If you have read CRPC, case diary is the day-to-day progress in the investigation done by an investigation officer. Now can it be shared? If you read CRPC, the CRPC says that the case diary is between the IO and the magistrate. Nobody else can have access or his senior officer. Can it be given to a private person? Because you get hundreds of applications. Again, it cannot be. Plus, you see a lot of these aggrieved parties come to use RTI to get copies of these statements. Now all of you are aware, any matter under investigation, under inquiry or under trial, the RTI shall not intervene. Why? Because it may spoil the trial, it may spoil the investigation. Therefore, the best method to get details of any statement which you need, the court has to provide it to the aggrieved person, to the victim, as per the CRPC. Therefore, indulgence in RTI at that level is not required. Now, where can RTI come into effect? Only when an investigation has concluded or when a trial in a court of law has concluded, then you can seek information through the RTI. So these are all the various pronouncements made under the RTI. Now you see one of the common questions will come before us is when you appear for a public service examination, for example UPSC, KPSC, can marks be disclosed to each one of you? What marks you secured? The RTI has prevailed upon that marks has to be given. Now you cannot ask how and why you got low marks. Those are beyond the domain of RTI. And the Supreme Court has also pronounced that in any public examination, the marks secured is relative to other candidates. So even if you are topping a public service examination with 50% marks, it does not mean that your knowledge level is only 50%. It is in relation to the candidates who appeared for the examination. And that is why no questions asked, disclosure of marks has been allowed. So these are various judgments which we scrupulously follow in the commission, and lot of details have been provided to individuals. That is why the percentage of seeking information, as I told you in one of the slides earlier, is only 45%. But my short experience in the commission has been lot of common people do gain out of the RTI Act. For example, we got an application today. His land was acquired long back. He is an illiterate person. He belongs to a village. He did not have the documents at that time to claim compensation. he has asked RTI to direct the public authority like Tehsildar to provide his document. Now these are the instances where you can intervene, bring lot of justice to a person who has been deprived of his legitimate right. For example, land acquisition. For example, somebody changing your land khata. If you are doing civil matter, you will realize hundreds of fraud takes place where your khata is manipulated and somebody becomes an owner, brings an injunction order from the court restraining you from entering your own property. Now these are matters where huge fraud occurs, and that is where the RTI becomes very, very handy and it can help a common citizen. So in conclusion, what I want to tell you is RTI is a very vibrant, very effective, and it is a very enabling act. It is not a punitive act. The punishment of 25,000 is a last resort. What we try to do during our hearings is to enable a person to seek as much information as possible. And my success is not dependent on how much fine I impose on any public authority. My success depends if I can raise the percentage of people seeking information from 45% to even much higher level. That is what gives greatest satisfaction, because then I have enabled a citizen of India to claim his bona fide rights. So with this I close my lecture. I am open to any few questions which you may like to ask, and I don't want to give you a very longish lecture today. It is just an introduction and just to sensitize you on RTI so that your interest is aroused and gradually you also can consider the domain of RTI in your career. Thank you very much.